Madam Halima Yacob, President of the Republic of Singapore, patron of the 8th World Congress on Family Law and Children's Rights. The Honourable Diana Bryant, Chair of the Board of the World Congress. Mr. Yap Teng Leong, Chair of the Family Law and Family Rights Section of Law Asia. Members of the Board of the World Congress, distinguished guests, ladies and gentlemen. I am honored to deliver the keynote address for this year's Family Law and Children's Rights Conference. It has become almost commonplace to begin an address in these times by making some observations about the effect of the pandemic on our lives. That is a reflection of the fact that this has been a time of great difficulty, suffering, and loss for many around the world. Indeed, with particular reference to the theme of this World Congress, we are reminded that for many families, this extended period of uncertainty, financial difficulty, and social isolation will have exposed or deepened the rifts and divisions in their familial relationships. In a very real sense, therefore, as professionals and persons involved in the field of family justice, the challenge of striving to ensure that we have the best possible systems in place with appropriate laws, procedures, and people has become ever more urgent as we endeavor to ameliorate the strain that the pandemic has exerted on so many families. That is just what we have gathered today to consider. And so I want to begin by extending my heartfelt thanks to the chairpersons and to everyone in the organizing committee for making this event a reality. More than a century ago in The Prophet, the famous Lebanese-American poet Khalil Gibran wrote these words about parenthood. Your children are not your children. They are the sons and daughters of life's longing for itself. They come through you, but not from you. And though they are with you, they belong not to you. The poem was published at a time of great change in family justice. In the late 1800s, the welfare principle was making its first appearance in English legislation and judicial texts. It posited that the welfare of the child is of paramount importance in all matters concerning the child. Its emergence reflected a larger shift in societal views, and consequently also in the attitude of the law towards the family. The law had historically harbored reservations about the extent to which it could properly intervene in family relationships. With the turn of the 19th century, however, there was a wave of economic and social transformations, including the women's rights movement, which brought about seismic changes in societal views on families. A new consensus eventually emerged that the law could, and in some cases should, intervene in family relations in order to ensure the welfare of the vulnerable ones, especially women and children. Looking at the arc of the history of family law, we might say that in accepting the welfare principle, the law was just beginning to come to terms with the sentiment expressed in Gibran's poem, that children are neither the property nor merely an extension of their parents, but rather are persons deserving of the law's respect and protection in their own right. More than a century later, we have come a long way. And the welfare principle is today thought of as the golden thread that runs throughout the family law framework of many jurisdictions. But for all the transformation that we have witnessed thus far, the work is not done. I suggest that we now stand at the cusp of a new wave of changes that will be no less significant or transformative. One in which the family justice system will come to terms with the inherent differences between family disputes and other types of disputes, and abandon the long-held precept, at least in the common law tradition, that it must be structured like other civil cases, according to an adversarial system of justice presided over by a distant and detached arbiter. By this, I am referring to the fundamental shift towards a model of therapeutic family justice. I suggest that this would emerge as an inescapable imperative if we were to try to see family justice through the eyes of a child. Because if we are serious about the welfare of the child being the paramount consideration in this context, then family disputes cannot be about legal battles, and children cannot ever be allowed to become the pawns of war or litigation outcomes to be won or lost. Therapeutic justice is not a new concept. As some of you will know, it was developed in the 1980s and 1990s by two mental health and disability law professors, David Wexler and the late Bruce Winnick. Perhaps because of their areas of specialization, they were particularly attuned to the potential of the legal system to touch and transform the lives of the individuals whose lot it is to interact with it. The idea is to identify and use the therapeutic potential of the law to maximize beneficial outcomes for its users. Contrary to traditional perspectives of the law, which emphasize its dispassionate and detached nature, therapeutic justice engages with the deeper human elements that underlie a dispute. That is, the social, psychological, and emotional aspects of the dispute. While it first gained traction in criminal and community courts, its influence can today be observed in many other areas, including in the family justice system. In Singapore, therapeutic elements are not new to our family justice system. Mechanisms that give effect to therapeutic objectives, such as mediation and counseling, have been gradually incorporated into our laws and processes since the 1990s, when dedicated family courts were first established. Last year, however, marked a milestone in our family justice history when we formally announced a concerted shift towards a vision of therapeutic family justice. In presenting this, I described our view of therapeutic family justice as a means of resolving familial disputes that is defined by three themes. First, it must be holistic, in that we must endeavor to take account of and address both the visible legal issues and the underlying non-legal causes. Second, it must be restorative, in that the law must endeavor to aid the parties to repair their relationships at least to a minimally functioning state. And third, it must be forward-looking, in that the law must encourage the parties to focus on their shared futures rather than leave them preoccupied with their painful past. There are no real winners in a family dispute, and it would only make things worse if we compelled aggrieved and agitated individuals to undertake a painful journey through a legal process that ensnares them in a vicious cycle of ill will and inflammatory remarks. As the Singapore Court of Appeal observed in a recent judgment, this shift towards therapeutic justice is not simply an aspirational ideal, but rather a necessary and defining object so that we can help preserve healthier and more constructive familial relationships, even in situations of disharmony and breakdown. As with all foundational policy ideas, our vision of therapeutic justice will need to be brought to life through a sustained, practical, and thoughtful review and reform of all aspects of the family justice system. I suggest that we can think of the changes needed to actualize these therapeutic justice values in three main aspects: our laws, our procedures, and our people. First, we must strive to ensure that our laws align with this vision. Virtually all human decisions and conduct occur in the shadow of the law, even before any formal legal process is engaged. Each society must wrestle with its own conceptions about marriage and families, making compromises and forging consensus on a range of legal issues, from the grounds of divorce to the obligations that spouses owe to each other and their children, both during and after a marriage. The answers to these questions will affect the ability of the law to achieve its therapeutic goals and the manner in which it best may do so. We can see this by imagining a fault-based legal framework in which every party seeking a divorce was required to prove adultery or some type of offensive behavior on the part of the other spouse. This would inevitably shape and influence the parties' mindsets and the kinds of allegations that they would need to investigate, raise, and prove in order to obtain a divorce. Judicial decisions and frameworks, too, can have a significant impact on the therapeutic influence of the law. In the context of the division of matrimonial assets, for example, Singapore courts have long adopted what we refer to as a broad brush approach when assessing and weighing the spouse's respective financial and non-financial contributions to the pool of matrimonial assets. Because of this, our courts will not mechanically scrutinize every deed or transaction or require proof of every contribution or payment towards improving or maintaining the assets. This arises out of the idea that marriage is not a commercial relationship, and that many things in a marriage are rightly done out of love and concern without records being scrupulously kept in anticipation of future litigation. This approach is not unique to Singapore, and it reflects a view as to questions of proof in family dispute resolution that is designed to reduce rather than exacerbate tensions between the parties. The second area of focus, which I would suggest is the most essential, is an honest and holistic review and reform of our dispute resolution procedures. This is pivotal because procedure is the gateway through which justice is accessed. Indeed, a key insight offered by the theory of therapeutic justice is the significant influence that a considered use of procedural tools can have on the parties, their attitudes and mindsets, and their ability to feel truly at peace at the end of the legal process. A procedural system designed with therapeutic aims in mind will likely have some distinctive features. First, there will be a greater use of non-adversarial methods to complement the existing adjudicative tools because spouses are not adversaries, but rather should see themselves as having to find a mutually acceptable solution to a shared problem. Indeed, the fundamental pursuit of family justice, especially where children are involved, should not be a single-minded inquiry into who is in the right and ought, therefore, to win, which is what typically characterizes adversarial systems. Rather, the key goal is the amelioration of tensions and the preservation of functional relationships so that the parties can continue to work towards their own welfare and especially that of their children. Second, the system will need to integrate multidisciplinary expertise, including non-legal expertise, to more competently deal with the range and complexity of human emotions and relational issues that underlie family disputes. This will require the involvement of experts like counselors and psychologists, both before and when the court processes are engaged. This is so that spouses and their children are given the support they need and judges have the information and tools needed to make constructive decisions. Third, there will be greater and more considered integration of technology. While technology will not replace the magic of personal contact and trust that is inherent in the practice of family law, a well-designed tech-enabled framework can help reduce unnecessary friction and anxiety for users navigating the legal system and facilitate access to family justice, which is especially important given the increasing number of litigants in person in family courts. This could be done, for example, by enabling certain applications to be filed and hearings to be conducted either online or from touch points in the community, rather than requiring physical court attendance in each and every instance, and by providing more digitized and automated services for common administrative requests and functions. The third area of focus concerns the people who will have key roles to play in this new vision of family justice. This includes family lawyers and judges who will need to be equipped with skills and knowledge beyond the law, such as interpersonal skills, basic familiarity with relevant social science concepts, and exposure to non-adjudicative conflict resolution methods. It will also require the training of allied experts from non-legal disciplines, including counselors, mediators, and child psychologists, so that they are sufficiently aware of the features of the legal system within which they operate and the legal tools that are available to achieve therapeutic outcomes. In the longer term, we will also need to review the education and training of our future family justice professionals. This will be a long-term process that starts from the early stages of legal education through to the bar and professional exams into continuing professional development. One example of how this is already being done is the law program at the Singapore University of Social Sciences, or SUSS. Founded with the mandate of training lawyers for family and other community law practices, SUSS requires its students to take electives in allied subjects such as psychology and social work. Such a holistic reform of our family law training and education systems will help facilitate a more fruitful and sustained collaboration between the different domains of expertise that are needed to work towards a shared goal. Beyond this, and speaking from the perspective of a jurisdiction which is in the midst of grappling with and implementing therapeutic justice, it seems to me that we cannot make effective progress towards a model of therapeutic justice just by introducing a new set of tools. We will need also to be particularly careful in how we choose to use them. As a lens of care, therapeutic justice calls for flexibility in how we approach each case. There can be no uniform prescription because an identical set of procedures might be therapeutic in one case, but not necessarily in another. It is crucial, therefore, that we develop the ability to triage cases and to calibrate the use of different tools to achieve therapeutic outcomes suitable to the context of each case. I can illustrate this by referring to how we approach judicial interviews of children. Used wisely, these serve to give a voice to the child, and research has shown that its use can benefit both the child and the family as a whole. At the same time, there are situations, some obvious and some less so, in which the use of such interviews may be less appropriate. The judge, assisted by other specialists, will need to consider what is best for the particular child, and if an interview is not suitable, consider the possible alternatives to achieve therapeutic outcomes while striving at the same time to give a voice to the child. Triage is also invaluable for identifying complex and high needs cases which require earlier and more intensive intervention. Our family justice courts recently adopted a pilot program to identify such cases early on and to have them dealt with by a multidisciplinary team of judges, mediators, counselors, and other professionals. The first cases have been identified and are currently undergoing the pilot program, and we are hopeful that the early intervention will prevent them from escalating as they otherwise might have done. The ability to calibrate and triage will be an essential feature of therapeutic justice. This is so because we deal with a broad spectrum of cases, and these can call for different responses. Take the examples of cases involving family violence. While a typical tool of therapeutic justice, such as mediation, may not be appropriate, other solutions might nonetheless bear fruit in an equally therapeutic way. My colleague Justice Debbie Ong, the presiding judge of our family justice courts, has related an encouraging story of a perpetrator of family violence who experienced healing and restoration in the course of court-ordered counseling. While he had initially been unwilling to undergo counseling, and in that context to discuss his personal issues with strangers, he found over time that he benefited from that process. In his words, it became possible with time to, quote, lay down our pride, drop the blame game so that we can actually protect the people who love us, unquote. It is therefore of fundamental importance that we pay careful attention to ensuring that we can triage cases and apply tools appropriate to the particular case at hand. Effective triaging will require the input of our practitioners and judges, whose experience, judgment, and wisdom will be invaluable. At the same time, we must complement this with empirical data collected by our family courts and with rigorous analysis from other domains of knowledge, especially in the social sciences. A combination of these human and empirical factors will strengthen our ability to triage matters, For example, by helping us better identify indicators commonly associated with cases that are either more or less amenable to child interviews, or the trends and factors typically associated with cases that will require more intensive intervention. In addition, our capacity to calibrate and triage can be improved with continued reflection on the best way to achieve the desired therapeutic outcomes in our family justice system. To that end, our family justice courts established an advisory and research council in 2020 for the precise purpose of bringing together the leading thinkers and researchers in the field of therapeutic justice from around the world. We have done all this in the belief that therapeutic family justice, buttressed by a strong system for the calibration and triage of appropriate procedures, will best serve the families who are looking for a way past their present conflict to a brighter future. I would like to close by returning to the theme of this year's World Congress, which invites us to look at family justice through the eyes of a child. I think this gives us the most compelling reason to embrace this shift towards therapeutic justice. What would a child wish for in a system of family justice? What would she need? Surely more than a fair set of laws, efficient court administration, or an impartial and intelligent judge. Surely more than anything else, that child needs a system that can sensitively manage and ameliorate a distressing personal and familial situation so that she can see and believe that there is a path forward beyond the present. The growing acceptance of therapeutic justice reflects a maturing in the family law as it comes to terms with its fundamental societal purpose. Therapeutic justice has the potential to revolutionize the family justice system by placing the human being at the front and center of the legal process. It marks an era in which Gibran's poem might seem to evoke an attitude towards children and families, which is not purely aspirational, but is ever coming within our grasp. The conversations we will have today are critical to charting the future of family justice and to making our system one that is worthy of our children. I look forward to the insights and views that will no doubt be shared over the coming days, and I wish all of you a productive and engaging conference. Thank you all very much.
Chief Justice, I'm really delighted to be able to be moderating this Q&A with you today because I was part of your international advisory group and very much in awe of the transition that you made and that Singapore made to the Family Justice Court. So it's a wonderful presentation and I'm looking forward to discussing it with you.
Thank you. Thank you so much, Diana. It really is a pleasure to be here with you. And let me also say that I'm deeply grateful that you were a part of our International Advisory Council. And I think you made tremendous contributions there. And we were really enriched by the terrific team of people that came on board and worked with us. So we're very, very grateful. Thank you.
It's a pleasure. And I think that was just one of the wonderful initiatives that you had to have an international advisory group. You know, not many jurisdictions are prepared to open themselves up to accept that there might be expertise elsewhere, and you did that. And from what I saw, you absolutely took it and ran with it.
Absolutely. I mean, we had so much to learn. There's no question about it. We really had so much to learn. And it made a tremendous amount of sense, I think, to have that council and to have the benefit of the tremendous advice that we had.
Okay. Well, let me ask you this. When you became Chief Justice of Singapore, your background had been predominantly as a commercial lawyer, a commercial law background, but you've passionately driven reform in family law. How did that transformation come about?
I think a number of things, Diana. First of all, I think the one thing that we all have in common is we are all members of families. And invariably, I think being a member of a family will have been a big part of our formative life experiences. You're right in saying that I didn't do much family work as a practitioner, except on a pro bono basis for sort of family and friends. But I saw that there was a real difference in the endpoint of family litigation, depending on whether it was approached as a battle or as a war, as opposed to when it was approached as a serious problem that needed to be solved. And when I layered onto that the experience that I had when I came to the court and served for a year as a judicial commissioner, hearing mainly trial cases, I did hear some family cases. And I recall the tremendous satisfaction I felt as a judge when I was able to point the parties, either myself acting as a mediator and helping to mediate a case, or pointing them towards mediation before a third party neutral, which produced a good outcome, a satisfactory outcome, a way for the parties to move forward. And contrasting that with the experience I had when there were cases where I was thinking, what's going on behind this slugfest that was playing out in front of me as the parties were fighting over each and every line of an account that was being taken. And I saw that there really was a big difference between those two types of situations. Now, when I came back to the Court of Appeal and when I became Chief Justice, I knew at that time that our thinking, our institutional thinking about family justice had evolved over a number of years. And it had evolved from starting off, as with many other systems, by being rooted in some sense of fault, to becoming much more alive to the reality that once the marriage had really broken down, it was best to start thinking about what comes next, rather than focusing on how or why it had got to this point. And even so, despite that evolution that had taken place, when I joined the Court of Appeal in 2012 and started hearing appeals, I noticed that family law appeals typically stood out for having the most affidavits, the most blistering criticisms of and attacks on the parties, the most persistent claims of innocence whilst making vitriolic accusations against the other side. And the parties would often do all this and seek to justify it in some sort of idea that they were acting in the best interests of the child. And it seemed to me that this really wasn't what less adversarial procedures was all about. And as I started to think about it, I sort of realized that the problem stemmed in part from the fact that what had been happening was an incremental journey of small changes that were sort of bolted on to one another. So let me give you an example. I think cross-examination had been generally excluded in family proceedings at the time. And this was driven by the idea that you didn't want to, or that you wanted to make matters a bit less acrimonious. Now, if you take that by itself, it can make sense. It can seem like a good idea. But the problem was that in many cases, it ended up having the opposite effect because people felt able to vent and say whatever they wanted to say because they didn't have to account for it. They knew they weren't going to have to face the music under cross-examination. And so it seemed to me that we needed a really fundamental review because we were dealing with the most intimate of human connections, a family relationship that was under the most intense emotional pressure and distress. And this was just not the way to go. And that's really why I got really moved to think about how to reform this. I felt that this was an area that touched every Singaporean, everybody who was here, and I thought that we needed to think about how to deal with this. So I had discussions with my colleagues at the Ministry of Law, the Ministry of Family Development. We talked about it. We agreed that this was a really worthwhile subject to look at because it was going to require legislative reform as well. And so at the very first legal year that I opened, the year after I took office, I announced the formation of an interagency group comprising people from the courts, the profession, and also from the ministries to undertake this reform process. And it led to a fabulous set of recommendations that eventually ended up with the establishment of our family justice courts. And in a nutshell, I think that sort of explains why it became such a centerpiece of what I wanted to do.
Well, you've certainly been passionate about it, in my experience. I've already touched a bit on the International Advisory Committee and how impressed I was and what an inspired decision it was. How did the idea actually come about to do this?
Actually, Diana, the idea sort of had its roots in the reform process that I talked about. So when we embarked on that reform process, our thinking was really shaped by a lot of inputs that we had picked up from studying systems abroad. So the team that did the detailed study after I announced the interagency team in 2013, I think most of 2013, 2014, they embarked on a big study mission and they visited a number of jurisdictions. They looked at your jurisdiction as an example. They looked at your jurisdiction, we looked at Germany, we looked at the UK, we looked at several other systems. And forming the IAC was almost a natural extension of that process, because in undertaking the reform process, we were looking at what other jurisdictions were doing. And it then made sense to get some of the leading thinkers from those jurisdictions to come and work with us to really see how far we could take this and how much we could polish and sharpen the product. So that was the first thing that drove it. The second thing that drove the establishment of the IAC was the recognition that even though we may have a lot of differences in our unique family law systems, there's a tremendous amount of common ground. And that's not surprising, because we're dealing fundamentally with the same kind of human issues. And so that again led me to think that there was certainly a lot we could understand by looking at how our partners in other jurisdictions were going about addressing some of these issues. And the third thing was I also wanted to bring in some expertise from people outside the law, because I felt that family justice was a particular area where judges could be greatly helped by having extra legal assistance and extra legal help. And so some of the members of that council, if you recall, were not lawyers, but they were people who were experts in other fields like child psychology or psychology for that matter. And they brought very valuable perspectives as well. And I think those were, broadly speaking, the sort of the three driving ideas that led to the establishment of the IAC. We were really privileged, I think, to find such a warm response. Privileged, and I have to say, in one sense, I wasn't surprised, because I was quite optimistic that we would get a positive response, because these are people who are passionate. And family justice is a space that you can't do it unless you're really passionate. And I really want to give a shout out to my colleagues in the family justice courts who do this every day, who go through the emotional challenge of dealing with these cases as best they can. So people who do this area tend to be really, really passionate about their subject matter. So I wasn't surprised, but I was very grateful and very, very really thrilled that we managed to put together this team of outstanding thinkers who came along, and we benefited a great deal from that journey. We really did.
Well, I mean, from my point of view, it was a very passionate group, and we very much enjoyed the meetings that we had in Singapore, and you, of course, were very hospitable. But we worked pretty hard. We had homework in between, and that was it. That was a good thing. So this wasn't. This was just not a joyride. Yeah,
it wasn't a joyride. And in fact, I think the IAC had a very, very tangible contribution to the work that we did. I mean, as you know, we discussed a number of ideas, and the third meeting in particular was the meeting, if you recall, when we tested out a number of ideas that led to our embracing this vision of therapeutic justice. And the background to that, Diana, I'll share it with you, but I'd been having a number of discussions with different parts of the legal profession. And in the course of one of those discussions, one of the groups I met was a group of family judges and family lawyers. And we started having, it was just a dialogue, and we started talking and thinking in terms of, you know, what we would do if we had a blank piece of paper. How would we design a family justice system if we had a completely blank piece of paper? And some of the ideas that came out of that were things like, why do we call people plaintiff and defendant? Why don't we call them mother and father or husband and wife? Because that describes their situation in relation to the problem that we're dealing with. Why do we refer to this as a writ, as though it's some kind of legal missile that you're launching? Why don't we have some other neutral nomenclature that gets people to change their thinking around it? It was that started us thinking about some of these points. And then we started researching therapeutic justice, and we ran a number of these ideas past the IAC at the third meeting, I remember, and got an overwhelmingly enthusiastic response. And I think that really inspired us to take this forward. And then the other thing was the superb ongoing exchange and assistance that members of the IAC have kept with us. You've worked with us on this Congress and on a number of other things. Matthew Thorpe has worked with us on giving lectures and so on. So several of the members have continued to work with us in a number of ways. And those relationships have been instrumental, I think, in helping our family judges, which has been another tremendous benefit of having the IAC.
Well, like all things, it works both ways. So it's been very enjoyable as well. Now, in the past 18 months really now, we've all got used to using technology in ways that we perhaps weren't using it before. So, Chief Justice, what are your thoughts about the future of family law and practice in the face of the rapid advances in technology, which is, I think in the last little while, been making traditional legal practice and business models inadequate to meet current demands?
Dan, I want to take this in two parts. Firstly, talking about the future of family practice, and then secondly, talking about how we've responded to it and how we've tried to prepare ourselves for that future. I think technology is going to massively disrupt, change many aspects of legal practice, including family practice, family law practice. And in thinking about this, I've suggested that we should think about technology impacting the law in terms of the products, in terms of the players, and in terms of the processes. What do I mean by that? In terms of the products, I think technology will really bring a proliferation of new types of products that can assist in the practice of law. Take a very obvious and easy example, predictive tools. We can all imagine that soon people will have available to them predictive tools that can anticipate the likely division of assets in a no-fault divorce. They're almost certain to feature in family practice. And whether courts end up using it, or the parties use it, or lawyers use it, the possibility of the parties getting more accurate information at an earlier stage of the process as to what's likely to be the end point of that has got to be helpful in the process. It's just got to be helpful in the process. On our side, we announced last year the anticipated launch of something called Litigation Assist. And this is a platform to assist litigants in person with digitized and automated generation and submission of court documents. I mean, litigants in person is a reality. We all are dealing with it all around the world, and perhaps in family justice more than in any other space. And so we can see the emergence of these types of platforms and tools that are going to help both lawyers and litigants in person and afford them the ability not just to prepare and file their documents, but also to connect with relevant stakeholders such as mediators, or lead on to something else, which is the second point I want to come to, which is the types of processes that we can expect. We can for sure expect that we're going to have things like negotiations or mediations, online negotiations that will be enabled. E-negotiations and e-mediations are bound to feature. And technology has a definite part to play in that. I remember some years ago, Colin Rule, I think it was, who spoke about an e-mediation platform that he was that he had launched that allowed people to mediate and resolve their disputes from the privacy of their homes. So those kinds of things are also going to be a part of how we see the future of family law practice. And then the third thing is players. I think technology is going to introduce a whole lot of new players who will work alongside some of the traditional legal actors. I think, again, a couple of examples. In the UK, there's a platform called Amicable that describes itself as the UK's #1 online divorce service. It helps people manage their divorces. You can get updates on paperwork. You can get automated process updates. You can ask questions of an artificial intelligence chatbot. In the US, they have a platform that offers private divorce proceeding, help with private divorces. So these kinds of things are definitely going to disrupt and have an impact on parties involved in family justice. For us, during the pandemic last year, when we had something close to a lockdown, one of the areas that we were most concerned about was family justice, because with people confined in spaces under situations of stress, you could imagine the potential for problems. This was a worldwide problem. So we set up the ability to conduct hearings by Zoom, but the problem was with a lot of litigants in person, they either didn't have the hardware or the software or the knowledge to access this. So what we ended up doing was we set up something called Zoom rooms, where people could go to a room and court technology was set up, connecting them directly to a judge. So we'll have to think about these things in thinking about this new world, and how do we ensure that we're prepared for it. I think the end point, even in this world, has got to be to think of how we can continue to deliver justice in a therapeutic way. And I think that no matter how much technology intervenes or comes into our space, I think there will continue to be a huge role for the good, sensible human advisor. And I think the task for family lawyers of the future is not to look at this from a competitive perspective, but really to look at this from the point of view of how to make themselves indispensable in this context, by emphasizing things like interpersonal skills, by emphasizing things like their familiarity with the therapeutic justice options and tools, by using their judgment and their skill and their sensibility to come up with best solutions for their clients. And technology, if we see it that way, and if we harness it that way, will be a great help rather than a threat to practitioners in the future.
Well, I hope that there are a number of family law practitioners listening to those wise words, because I think there's a lot to be said for that. Family law is, we've seen in the last couple of decades, is really global. For most countries, parties and families move between countries. International family laws become a very big feature. What do you see as some of the pressing issues that the global community will need to come together to address in the family justice space?
I agree, Diana. I think, in fact, last year when I spoke at our Law Society's Family Law Conference, I said that one of the main issues is the problem of how we're going to resolve disputes involving international families, because that's just a reality of the world today. I think with connectivity, we're seeing people marrying across jurisdictions. We're seeing people with assets in more than one jurisdiction. And unfortunately, when those marriages fall apart, as they sometimes will, there are a host of different problems that arise in connection with the conflict of laws, from multiplicity of proceedings, from trying to race to judgments in one jurisdiction or the other, from enforcement, relocation, international child abduction. I mean, there's a whole new level of complexity and difficulty that this poses. The rules of private international law, which have been developed primarily in the commercial context, are well developed, but they don't really provide a fit for purpose framework in the context of family cases. Because family cases require greater certainty, they require more timeliness, they need to be cost effective, and they need to be sensitive to the human condition and the emotional nature of the issues that we're dealing with. And if we think of the cases in the past, there are cases that have really given rise to problems. I mean, I came across the case of the Gilmore case, which involved competing proceedings in Australia and New Zealand, and both spouses had each commenced proceedings in one jurisdiction, and each jurisdiction had rules that favored the party that had commenced proceedings there. And then you had jurisdictional objections taken in both jurisdictions. Both courts granted stays, concurrent proceedings went ahead, and it's really giving rise to a problem when you end up in a situation like that. We dealt with a similar situation a few years ago involving Singapore and Hong Kong. What I did in that case, when I was made aware of the fact that there was this competing situation, what I did was to encourage the courts to speak to each other, to encourage the courts to communicate with each other so that they were mindful of what was happening in the other jurisdiction, and so they would try and deal with the matter in a holistic way. And I think that that is really one of the things that we should be thinking about as we look ahead. I think, Diana, that when we think about this issue, the global community should be thinking in terms of two or three things. First of all, if we actually stop to think about it, because of how much common ground there is amongst jurisdictions generally in thinking about family law, it is actually possible to construct a set of values that is subscribed to by the global family justice system. I've suggested this in a speech that I delivered. And I was surprised by how much commonality there is amongst jurisdictions in terms of setting out that core set of values that unites the global family justice system. The second point I've suggested is to enhance communication and cooperation between family courts and institutions. We kind of have a lot of that already with the Hague network of judges, but beyond the Hague network of judges, I'm thinking in terms of courts speaking to each other. Because sometimes you just want to know what's going on in the other court, and you want to be able to find out how the other court is likely to deal with the matter. And thirdly, to think in terms of respectful convergence of certain principles that at the same time recognizes that there are some differences, but as far as possible to try and move towards a convergent idea. And I think a lot of this can be greatly helped by having things like court-to-court protocols, or rather protocols for court-to-court communication, where the parties understand that this is actually very normal. It can happen. It's very beneficial. There's nothing to be suspicious. There's nothing to be concerned about. But it is going to be important to set out a clear understanding of the rules so that the parties don't end up with dashed expectations. I think that's the part we need to be careful about. But there's no reason why it can't happen. And we in Singapore have taken the initiative to advance this in the context of cross-border insolvency. We've set up a protocol for court-to-court communications, which has been adopted by many courts around the world now. So there is a system in place for cross-border insolvency for them to talk to each other. I don't see in principle why we can't do something very similar in the space of cross-border family law, which I think would really help in the resolution of a number of these issues.
I completely agree with that, Chief Justice. I think that's a great initiative. And as you say, we've had it with the Hague Network of Judges, but I've seen it done between Canada and the United States, where courts spoke to each other. And I agree with you. I think courts are sometimes too reticent to do that and perhaps too protective of what they see as their own patch to do it. But it's really, really important. And I think a great initiative on your part. Chief Justice, you spoke about Singapore's compelling vision for therapeutic justice and how it could fundamentally alter the way that family justice is administered and experienced particularly. We tried to do this in Australia some years ago with some successes and with also some failures. So I'd be interested to see what you think is what are the possible challenges in the roadmap for Singapore to reform the landscape and affect the cultural change that's necessary.
I thank you, Diana. I think the first thing is none of us should underestimate the scale of the task. It's going to be a big task to really integrate therapeutic justice into the system. It is going to be a challenge. I think that in doing this, we're going to have to keep an eye on how society's thinking about family issues and society's views on things like marriage and divorce are developing. I think that can have an impact. Why do I say that? I think that how we present this is very, very important. If people see this as, for example, if people see this as fundamentally designed to make divorce easier or to undermine the importance of marriage as an institution in society, at a point in time where that may not reflect society's values or society's views, I think it can lead to misunderstanding, and it can lead to a loss of legitimacy and a loss of support for it. So I think it's going to be very important to communicate the key points of what therapeutic justice is all about. It is not ultimately about devaluing marriage. It is not ultimately about making divorce easy. It is really about looking to the future and trying to position people who have come to the view that their marriages are at an end in a situation where they can look to the future rather than be trapped in the past. I think that's a message that's very important to get across, and we need to be very careful in putting this across. So I think that's one of the things: the communication, the explanation, and how we present therapeutic justice, what its underlying values are. I think that needs to be carefully enunciated so people understand it and they can see the value of it. And as part of that, I think it's also important to make sure that people understand the harm we're trying to avoid from having proceedings that are just too acrimonious and ultimately destructive to children. I mean, the science is clear that the best predictor for in terms of outcomes, favorable outcomes for children of divorces, is the degree of acrimony in the divorce proceedings. The less there is, the better chance there is that the children will come out of this fine. The more they have intact relationships with both parents, the better the outcomes for them, the predictive outcomes for them. So those kinds of points, I think, are very important to explain the points, articulate them correctly, and get support from society. I think that's very important. The second point is, I think we have to have a good dialogue with the other branches of the government, because some of the changes are going to involve legislation. They are going to require support from the ministries, and ensuring that the reforms that are implemented cohere with the intended policies of the government. I think that's also going to be something that we need to keep an eye on, but I don't see as much difficulty there, because, as I explained earlier on, the reforms that we have embarked on have very much been on a shared platform where we've had interagency discussions and we've worked together, and we're very much aligned with wanting to move in the best interests of our society. The next thing is going to be to get buy-in from our people. This includes our judges, this includes our lawyers. I think change management is going to be a big task. And change management is about explaining not only the changes, ensuring that they are trained, ensuring that they are equipped with the necessary knowledge, ensuring that they aren't under pressure, because you don't want family lawyers worrying that, oh, this is going to come back with a ethical complaint or some other complaint because I'm trying to do what I think is right, but somebody's going to turn around and say, oh, this wasn't a very therapeutic way of doing it. So you want to be very careful with managing this process with your judges, your lawyers, your experts, but also you want to be careful not to let it be a label that people misuse. And the problem with all these labels, I think, for example, of the rule of law, if you think of the number of disparate people who have marshaled that term in service of their own agendas, you can see that if you're not very careful with how you define your goals and how you define your concepts, it can be sidetracked. It's very, very important, I think, to avoid that. I think training is going to be very important, and we've implemented a number of training programs for lawyers and judges to get the basics across. And it's part of that we found formed an advisory and research council bringing together experts in therapeutic justice to help guide us in this process of implementation, to try and make sure that we're doing this in the right way and not losing sight of some of the key sort of values along the way. And then the next thing I think is to recognize that when we deal with divorces, we are dealing with human beings, and we're dealing with human beings who are extremely stressed and distressed. And sometimes one of the parties, if not both, but sometimes one of the parties is just not in a position where he or she is able to and ready to embrace the future. And you have to recognize that reality and not say, therefore, we give up on this. You have to recognize the reality that sometimes it's just not going to be that easy to implement it. And I think you have to look past that and try your best to think of alternative tools, of alternative procedures that may yet get you moving in the right direction, even if they can't all be harnessed within one setting.
Yes, well, I mean, changing culture is a big thing. Change management's difficult. Good luck with that. In your opening speech, Chief Justice, you mentioned that the restrictions necessitated by the pandemic may have caused family relationships to worsen. And we're now really more than a year after the pandemic, and I guess some of the problems are becoming chronic rather than short term. Do you see any urgent or important problems arising out of the pandemic, and how might the family justice system approach them?
I think for us in the family justice space, the biggest task for us actually was to ensure access to justice. And certainly at the acute phase of the problem, when it was literally difficult to move and gain physical access to the courts, one of our key focal points was to try to make sure that we could enable people to come access the court through technology, through the Zoom rooms that I mentioned earlier on, and as far as possible to enable them to continue to seek assistance from the court. But beyond sort of physical access or access through technology, I think at a substantive level, what I think many jurisdictions around the world have encountered in terms of the pandemic has been some of the issues like abuse that seems to have gone up. I mean, both psychological abuse as well as physical abuse, emotional abuse. We've seen some of those emerging as a consequence of some of the rather unprecedented constraints that people have been subjected to and that they've had to experience in the course of the last year and a half. In Singapore, our numbers have been relatively small, but even so, our numbers do show an increase, a noticeable increase in terms of things like abuse cases, domestic abuse cases, and so on. So we will have to think, we will have to recognize that and ensure that we are responding to that reality by making sure that people are aware that the courts are here, that we are open for business, that we can be accessed, and that we can provide relief where needed. I think that there are different ways that we're thinking about this. And one of the most interesting things that we're thinking about is actually a plan called Family Justice Without Walls. And that is actually a scheme that we are exploring in order to enable people to make applications for things like protection orders in community touch points within the community, at agencies within the community. And we want to make it such that people can get information, they can understand what their avenues are, and they can even file these applications without having to travel a long distance or without having to come to the court, which can be a forbidding experience in and of itself. And I think that this is part of a broader vision where we want people to understand that the family justice system is not a distant and remote, dark place, but it's actually here to help them address some of the real issues that they have to tackle in their lives. And I think that's probably one of the most important lessons that we've learned and that we're still grappling with at this time.
Well, thank you very much, Chief Justice, for your time today. I mean, one of the later sessions on our first day is going to be a session from the Family Justice Courts, where we're going to hear from the judges and the other members of the court who are involved in the practical application of exactly what you've been talking about. So we'll very much look forward to that. And I'm sure anyone who's watched this will be very impressed with what Singapore is doing and wish you very well in this enterprise.
Thank you so much, Diana. Thank you so much. I really want to take the opportunity to thank you, to thank all of our friends who have helped us at the International Advisory Council and now with the Research Council as well. But I also really want to thank my family judges and all those actually around the world who are involved in the enterprise of administering family justice. It's a real calling, and I think it takes a tremendous amount of courage and conviction to take that calling and to resolve to say that each and every day I'm going to do this with devotion to try and do right and help families who are going through probably one of the worst experiences in their lives. And they're not appreciated. A lot of the time, family judges are not appreciated. And I want to just thank all those who are involved in this enterprise. It's such an important work. Thank you.
Thank you, Chief Justice.